How a 1980 mineral rights letter led to a 7-month land recovery investigation. A Freedmen Reparations Fund Trust educational case study. In many families, the first sign that old land still exists comes from something small: a tax notice, a deed fragment, or, in this case, a letter from 1980 discussing mineral rights under a property no one could locate. For more than 40 years, the family didn't know where the land was located, who the current listed owner was, whether the property still existed at all, why a mineral rights company contacted them in the first place. The parish records did not match the family's history. The legal description was confusing, the assessment numbers seemed inconsistent, and no one knew how to connect the information. This is exactly the sort of situation the Freedmen Reparations Fund Trust, FRFT, was created to resolve. The problem that started in 1980. The family received a mineral rights letter in the early 1980s. The letter referenced a tract of land, a mineral rights inquiry, the belief that the family had ownership under the surface. Yet no one knew where the tract was located, how it related to their ancestor, whether the family still owned anything, what happened to the surface land, whether the minerals were still theirs. For decades, the letter remained a mystery. The parish provided little clarity. The mapping system was inconsistent. Land descriptions changed over time, and no one could explain why the mineral company contacted the family in the first place. How the FRFT investigation began. This year, the trust was asked to help determine where the land actually was, who the rightful heirs were, whether the mineral rights were still connected to the family, whether the land had been sold or misclassified. The investigation took 7 months and required reviewing historical maps, examining parish assessment archives, cross-checking land descriptions across different eras, rebuilding a family tree back to the 1800s, comparing old mineral letters with new records, triggering corrections with the assessor's office. What we found was surprising. Key findings. 1. The parish had difficulty locating the land themselves. Their records did not match the original mineral rights letter. The descriptions were inconsistent. Initial information sent to the trust was incorrect. Only after multiple inquiries did the parish re-examine the data. 2. The land had been miscategorized under multiple names. Before the investigation, the property appeared under various unrelated individuals. Parcels were split in unusual ways. Some portions reflected old transfers from the 1940s. Others remained frozen in an estate name. This is why the family could not locate it for decades. 3. After the trust began contacting the parish, the record was corrected. Once the genealogical and documentary proof was presented, the land record was shifted back, the correct estate name reappeared. The property was aligned with the appropriate ancestral line. This correction would not have occurred on its own. SATA 4. The mineral rights component was key. The 1980 letter was the only surviving clue that the family once owned both surface and mineral rights. A mineral company recognized the family connection. The rights may still legally belong to the heirs. It was this single letter that ultimately uncovered the estate. Why genealogy was necessary. County records alone were not enough. Maps were not enough. Assessment numbers were not enough. What unlocked the case was genealogy. Establishing the ancestor who originally held the land, rebuilding the family line to confirm the living heirs, matching the lineage to the mineral rights correspondence, providing the family connection that the parish needed to correct the record. Without genealogical proof, the parish had no basis to update the estate. The heirs had no legal standing. The mineral rights history could not be traced. The land's location could not be verified. What FRFT does in situations like this: the trust provides verified beneficiaries with land and estate investigations, reconstructing land histories even when counties cannot, genealogical verification, confirming rightful heirs so they can legally act, succession preparation, drafting affidavits and filings to reopen or establish an estate, record correction, working with parishes and counties to fix ownership information, long-term protection. Once ownership is restored, heirs may choose to place the land into the trust for legal protection, structured management, prevention of future misclassification, mineral rights oversight, Succession stability. Why this work matters. Many families have no idea that property is still in an ancestor's estate. Mineral rights are still legally theirs. Old letters or documents may hold forgotten value. Land may be misclassified in county records. Heirs retain rights even when surface land was sold. This case demonstrates that land recovery is not only possible, but often hidden in plain sight until someone does the deeper research. Conclusion. A single mineral rights letter from 1980 initiated a chain of events that led to identifying an ancestor from over a century ago, locating lost land, correcting parish records, clarifying rightful ownership, positioning an heir to restore the estate. This is the work the Freedmen Reparations Fund Trust performs for its verified members. Not just land recovery, clarity, protection, and the restoration of rightful inheritance.